Today we're going to talk about estate planning for young adults. My name is Gregory Singleton. I'm an estate planning and probate attorney. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities as well as greater Minnesota. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. So once a person turns 18, their life changes dramatically. They can vote, they can drink in England, their parents no longer have control over their person, and they're an adult. With that comes some responsibilities, one of which is estate planning. The question I get asked a lot is, how old should you be when you start to do your estate plan? And a lot of people wait until their retirement age. More people wait until they've had their first child or gotten their first house or accumulated a certain number of assets. Realistically, there's parts of your estate plan that are important to have as soon as you hit the age of 18. So let's go through these documents a little bit and talk about some of what's needed, what's not, and why, and we'll go from there. Let's start with the will. Now, interestingly, you can first have a will in Minnesota when you turn 18. Under the age of 18, you can't have a will. At the same time, you're not allowed to inherit in Minnesota until you turn the age of 21. Just kind of interesting there. So with a will, when you turn 18, maybe you're going off to college or leaving the house for the first time, you probably don't have very many assets. So the need for will may not be there. I may be the first estate planning attorney that says that someone does not need a will, but realistically, it might not be necessary. On the other hand, when people graduate college, sometimes they get high-paying jobs. Sometimes people inherit things. Sometimes people come into money in another way, such as developing an intellectual property or something along those lines. In those cases, once those assets start accumulating, maybe it's a good time to start getting a will, but until then, probably not the most important thing. The next document is the healthcare directive. Now, as you probably recall from other videos, a healthcare directive does two things. One, it gives someone authority to make healthcare decisions on your behalf when you are unable to make those decisions for yourself. And two, it identifies what those decisions you want to be. I think everyone should have a healthcare directive, especially people in their 20s, because when people are in their 20s, they are doing things like extreme sports, drinking heavily, driving fast, being 20-year-olds. With that comes some inherent dangers. And if something happens to you, all of a sudden, your parents don't automatically have authority to make decisions on your behalf. So if you want your parents or somebody else, a boyfriend or girlfriend or a fiance or something along those lines, to make those decisions for you, you need to get a healthcare directive in place. You also need to put in place a HIPAA waiver. As you may recall, HIPAA is the law that prohibits people from accessing medical records of other persons without permission. Getting in place a HIPAA waiver gives that permission to your healthcare agent so they can actually be informed about what's going on before they have to make those decisions on their own. The next document is similar to a healthcare directive, and it's going to be the financial power of attorney. Now, in estate planning, in general, a financial power of attorney allows someone to have access to and to make financial decisions on behalf of another person. On the one hand, kids are independent for the first time, and they may want to claim their independence. On the other hand, kids may need someone to look over their shoulder while they're in their 20s. They may need someone to bail them out. They may have an emergency, and having someone with the ability to access their financial records may be able to help that out. Notably, normally when I talk about a durable financial power of attorney, I'm talking about a power of attorney that is springing, that comes into effect as when someone becomes incapacitated, either has dementia or goes into a coma. In this case, I'm just talking about a financial power of attorney, which is not springing. That is immediate. It immediately has power. Now, remember, a person who has a financial power of attorney, they can retract it at any time. So if, as the person gets older and more responsible, they can say, I want this power of attorney over. They can do that. The next issue with estate planning that I think is important for when kids turn 18 is actually cabin planning. A lot of people, when they have a family cabin, they want to keep it in the family, so they'll put it into a trust or they'll put it into an LLC or some other business entity. It's a great time when kids turn 18 to start giving them some more responsibility. You can give them ownership in the LLC. You can make them a trustee with limited powers in the trust. It's a great way to pass the torch to the next generation as they move forward. The final document I want to talk about is not usually or generally an estate planning document, but I think it kind of goes into that category. It's called a FERPA waiver. FERPA stands for the Family Education Rights and Privacy Act. Basically, from grades K through 12 up until the kid is 18, a parent can look at their child's grades. Now, once the child turns 18 and they're an adult, the parent loses the ability to check on their grades. Now, on one hand, the kid may not want their parent to check on their grades, but on the other hand, if the child is going to college and the parent is paying for part of that college, the parent may want to have a right to check on the grades of the child. It's a good trade-off for paying for college. So it's something to keep in mind when you're doing your estate planning documents for the kid going off to college. You might want to put in a FERPA waiver as well. So that's generally it. That's what my take on estate planning for young adults that are leaving the house for the first time, maybe going to college. If you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. We have a new video comes out every other Wednesday. So if you subscribe, you'll get access to that. If you have any questions, please leave them in the comments below. I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.